disputes and the important role that Hong Kong will play in the operation of IOMAC. Put it simply, mediation is a process whereby the parties in dispute attempt to reach a mutually acceptable and amicable settlement of their dispute on a voluntary basis with the assistance of a third party who may facilitate a solution between the parties to the dispute, but without the power to impose it upon the parties. As compared to traditional means of resolving international disputes such as litigation or arbitration, mediation is clearly more forward-looking, constructive, and conducive to repairing the relationship between the two sides. It's true that peaceful settlement of international dispute is one of the most fundamental principles of international law and international relations. The use of mediation as a means to settle international dispute peacefully is expressly mentioned in Article 33 of the Charter of the United Nations and also the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations passed by the United Nations General Assembly in 1970. The United Nations General Assembly has passed altogether 4 resolutions on strengthening the role of mediation in the peaceful settlement of dispute, conflict prevention and resolution. On the 22nd of June 2011, 13th of September 2012, 31st of July 2014, and the 9th of September 2016, respectively. In the most recent one dated the 9th of September 2016, the UN General Assembly recognized mediation as an efficient and cost-effective tool in the peaceful settlement of dispute, conflict prevention and resolution, and welcomed its increased use. It acknowledged the importance of mediation in the peaceful settlement of dispute, conflict prevention and resolution, and in seeking long-term political solutions for sustaining peace, and recognized that mediation needs to be further and more effectively used. On the other hand, the role of mediation in resolving international commercial and investment disputes between a state and a foreign national or between private entities from different countries is also well acknowledged and recognized. As early as 1980, the United Nations Commission on International Trade Law, the UNCITRAL, developed and adopted the UNCITRAL mediation rules, which were subsequently revised in 2021. And more recently, in 2024, UNCITRAL published the Guidelines on Mediation for International Investment Disputes. The United Nations Convention on International Settlement Agreements resulting from mediation, which entered into force in September 2020, offer another example of international efforts in promoting mediation. While mediation may be conducted on an ad hoc basis, there are clear advantages to conduct mediation with institutional support. Institutional support may include, for example, guidance of procedural aspects, assistance in communicating with the other party, identification of a pool of mediators, and assistance in their selection and appointment, assistance in the logistic aspect of mediation, including the organization of in-person and remote meetings, as well as providing for data protection and cybersecurity measures, etc. In these circumstances, in order to promote and facilitate the use of mediation to resolve international disputes, it's most desirable to have an intergovernmental organization devoted to the use of mediation to resolve international dispute. The establishment of IOMAC has filled a glaring omission in the past international dispute resolution system. The organization will complement the other 2 intergovernmental organizations specialized in international dispute resolution, namely the International Court of Justice and the Permanent Court of Arbitration. The headquarters of IOMAC will be crucial to the implementation of the Convention. It represents the physical presence of the institution and provides the platform to provide various mediation services. I'm extremely grateful that the state parties to the Convention have agreed to establish the headquarters of IOMAC here in Hong Kong, which is a strong vote of confidence in Hong Kong. I will respectfully submit that Hong Kong is indeed an ideal place to host the headquarters of IOMAC. Hong Kong is a special administrative region of China, which has taken the lead in the establishment of IOMAC. Under the principle of one country, 2 systems, Hong Kong enjoys numerous unique advantages. which put it in the best position to serve as the headquarters of RMAC. As President Xi Jinping said on the 20th of December 2024 in Macau, at the ceremony celebrating the 20th anniversary of China's resumption of sovereignty over Macau, the principle of one country, two systems embody the fundamental values of peace, openness, harmony, and sharing. These are also the intrinsic values behind the convention. Hong Kong is a well-known world-class international financial trading and shipping center. Its geographical location, well-developed transportation services, and liberal immigration policy ensure that people from around the world may and come easily here. Hong Kong is also one of the safest and most friendly cities in the world. We offer diversified services in different aspects to suit the needs of people speaking different languages, coming from different cultures, religions, and countries. But most importantly, in the present context, under the principle of one country, two systems, Hong Kong is the only common law jurisdiction in China and the only bilingual common law jurisdiction using both Chinese and English in the world. We have a strong pool of legal professionals coming from different jurisdictions who specialize and experience in international dispute resolution. The legal system of and the legal services provided by Hong Kong are highly international, reputable, and efficient. It's undoubtedly an international legal service and dispute resolution service center. Hong Kong has been a keen supporter of mediation. The Hong Kong SAR government has formulated a comprehensive set of policy initiatives which aim at deepening the mediation culture in Hong Kong. For example, the policy statement on the incorporation of mediation clauses in government contracts was issued in November 2024. As a matter of general policy, the government will incorporate a mediation clause in all government contracts. By taking the lead, it's hoped that private entities will be encouraged to include mediation clauses in their contracts, thereby deepening our mediate-first culture. Turning to capacity building regarding international mediation, since 2018, the Department of Justice has been co-organizing with reputable international organizations almost on a yearly basis, investment law and investor state mediator training in Hong Kong. The Hong Kong International Legal Talents Training Academy, under the Department of Justice, was set up in November 2024, which may collaborate with the IOMAC in organizing capacity building program on international mediation in future. Hong Kong is also seeking continuously to foster legal cooperation with other jurisdictions. It's our honor that in a moment, the Department of Justice of Hong Kong SAR government will sign a memorandum of cooperation with Cambodia. And on this very happy and positive note, I would like to conclude by wishing you all a very fruitful and constructive forum this afternoon. Thank you very much.
Thank you. Thank you, Secretary Lam. And please have a seat. Today, we will witness the signing of the MOU, a Memorandum of Understanding between the Department of Justice of Hong Kong Special Administrative Region and the Ministry of Commerce of the Kingdom of Cambodia on legal cooperation. The MOU provides a framework for strengthening collaboration, communication, and cooperation between the Hong Kong SAR and Cambodia on issues relating to dispute avoidance and resolution, and to facilitate the development of the related services, including mediation. May I now invite the Secretary for Justice of Hong Kong SAR, Mr. Paul Lam, and Her Excellency Tram Nic Mo, Minister of Commerce of the Kingdom of Cambodia, to please come on stage and take your seats. Before we proceed to sign the MOU, please take a photo to capture this important moment. Please proceed to sign the MOU. Thank you. May I now invite Secretary for Justice and Minister of Commerce to please step forward to the front of the stage and take another photos. Once again, thank you. The Secretary for Justice of Hong Kong SAR, Mr. Paul Lam, and Her Excellency John Nick Mo, Minister of Commerce of the Kingdom of Cambodia. Thank you very much. Thank you. And please have a seat. This marks the end of the MOU signing session. I am sure we will all look forward to the strengthened cooperation, including any capacity building on international mediation. In fact, we gather this afternoon to look at the development of international mediation. There will be 2 sessions for today's forum. The first session will be on state-to-state mediation, and the second session will be on international investment and international commercial dispute mediation. Details of the program are available by scanning the QR code inside the card for the event. We will first begin with the discussion on state-to-state mediation. Ladies and gentlemen, please welcome the moderator of the first session of the forum, the Honorable Professor Teresa Chang Yok-Wah, GBM GBS SCJP, former Secretary for Justice of the Hong Kong SAR, and founder member and co-chairman of the Asian Academy of International Law to the stage. May I also invite our 9 distinguished speakers to please come on stage. Let us give a warm welcome to H.E. Alif Hafez Uglusano, Vice Minister for Foreign Affairs, Indonesia. Dr. Danilo Turk, former President of Slovenia. Judge Ong Shokai Takasone, former Vice President of the International Court of Justice, former Prime Minister of Jordan. Professor Dr. Surakiart Sathirathai, former Deputy Prime Minister and former Minister of Foreign Affairs of Thailand. Judge Abdul Korma, Judge ad hoc of the International Court of Justice. Mr. Xia Huang, Special Envoy of the United Nations Secretary General of the Great Lakes region. Judge Gao Zhiguo, former judge of the International Tribunal for the Law of the Sea. Mr. I Gusti Agong Wasaka Puja, Executive Director of the ASEAN Institute for Peace and Reconciliation. Mr. Boris Kalashevich, Deputy Head of the International Committee of the Red Cross Regional Delegation for East Asia. H.E. Gideon Timotheus Husband, Minister of Foreign Affairs of Ethiopia, who will be joining us by video. Thank you. And now I will pass the time to Professor Chan.
Your Excellencies, distinguished guests, ladies and gentlemen, good afternoon. I am indeed very honored and privileged to be the moderator of this session dealing with state-to-state disputes through mediation. The signing of the Convention on the Establishment of the International Organization for Mediation actually is a very significant step towards providing the international community with a very viable alternative for conflict resolution. As you can see in the convention, it provides for two scopes of disputes, very broad scopes. First, that of state-to-state disputes, and the other in the context of international investment and international commercial disputes. So in this particular session, we are going to hear from the experts in the context of state-to-state disputes. We've heard actually in the signing ceremony this morning about the benefits of mediation and of course how states can actually utilize mediation to actually advance a number of very positive goals. Not only will it further global governance, it will no doubt also enhance the collaboration among states. And I think if I can also say, it not just provides for procedural fairness, but will look towards an outcome fairness approach, which will all be beneficial to all the states who are going to be involved. Now, with me here today, there are the experts that you've heard as they come onto stage, their experience, but as you will hear from their speeches, you will hear the perspectives from their own states, from their international organizations, and of course from the experience that they have had. And I think I am indeed very excited to be here, sitting among these experts, former heads of states, current ministers, as well as some judges from the international courts. So I think in the interests of time, and without further ado, I'm going to ask His Excellency Arif Hafaz Ogransano, the Vice Minister of the Foreign Affairs of Indonesia, to first give a speech. He will tell us, I believe, something about how Indonesia has embraced the concept of mediation, and of course also some other thoughts as well. Your Excellency.
Thank you very much, Professor Teresa. I also would like to give my respect to Mr. Paul Lam, who kindly opened this session this afternoon, and also ministers and judges who are here today, and many of them I know personally. I would like to share with you three elements on mediations that Indonesia is so closely involved. The first one is the domestic landscape, Professor. The second one is the international landscape. And I think the third one is the relations of our experience with the IOMED. On the domestic landscape, mediation is actually by law recently been made mandatory. So the Supreme Court has issued rulings on the procedures to conduct mediations as mandatory. element in civil cases in Indonesia. And as a result, in 2023, for instance, we have settled 104,000 cases in Indonesia via mediations. It comes in the form of civil cases. It comes in the form of inheritance cases and other types of dispute that I think were settled through the process. Well, I have to be frank, not all of them are successful. Around 25% are successful, and the rest, they go to the normal proceedings in the civil procedures court. Now, I think the reason why the regulations on compulsory mediations was made is because it is considered to be faster, cost-effective, creates trust in dialogue, and I think in many social issues it maintains the social harmony of the people involved in those many cases. We see a lot of mediation cases in terms of with the government, for instance, land disputes, exchanges of lands with national projects, for instance. So mediations played a lot of role, and in this particular context, I believe 90% success rate in many government projects are settled through mediations. Now that is the domestic landscape, which means that the legal thinking in Indonesia is very much in favor of having mediations in our system. Now, at the international context, the international landscape, I can start with the political mediations that Indonesia was involved. If you recall, there was a conflict at the end of Indo-China War. It was a very complicated conflict in the 1980s, 70s, 80s, and Indonesia initiated the mediation process that was called the cocktail party, where our foreign minister invited the relevant parties in the Indo-China conflict to come to Jakarta at that time. I was a very junior officer in the 80s. I helped the foreign ministers in a very unsubstantive work at that time, but I saw how mediation process was done, how these foreign delegations met our foreign minister, each of them separately, and how position was developed, and how finally the discussion was also made, and we came up with political decisions that end the Indo-China conflict. And we also had the experience of mediating the case between the Philippine government and MNLF. I was also involved at that time, and it was a very interesting process to follow, more or less the same with the political process that we see in the Indo-China mediations. And of course, Indonesia itself was mediated when we had a conflict with the armed groups in Aceh. We have a mediator from Europe, and we finally had an agreement with the Aceh rebels in 2005, and that became a political settlement in the context of Indonesia at that particular time. But also at the issue of trade as well. We are quite active in the mediations elements. We are working, for instance, with different countries in the FTA, in the free trade agreement, and we include mediation in that document as well. We are now in the process of ratifying the PCA agreement. We will consider also ratifying the Singapore Conventions on Mediations, and as well as we are working very actively with colleagues in UNCITRAL on the ISDS reform. So at the international landscape, we are quite active in the mediations, and again, we are looking at the merit of the mediation itself based on our experience at domestic level. Now, the last part of my quick remarks is about the relationships of our experience domestically and the IOMED. I think our experience has become a main factor on why we want to join the IOMED, and we are very active in the discussions of the establishment in the first place, because we see the merit of the IOMED. We see that there is still a gap on the mediation between state to state level. Yes, there are international conventions on mediations embedded over there, but I think in terms of a organization as such, I think this setup, these organizations will become a very important element at the global landscape, global legal landscapes on mediations. And of course, being in Hong Kong, it's a very important element, as well as Excellency Paul Lam mentioned, the positions of Hong Kong itself. I think it's very, very important. Now, we, Indonesia, of course, will be very active in our contributions to the final definition later on the rules making, on the mediation rule itself. And we will also be very active in the contribution on the operation of the IOMED itself. So I think with that, I would want to close by saying that the establishment of the IOMED is timely. It's a bit late, Professor, actually, but it's great that it comes into form. And it's so timely looking at the geopolitical situations today. And I think it's also a strong message to the world that instead of confrontations, we are choosing cooperations through this forum. So once again, Prof, thank you very much for inviting me to be here on the podium. And Indonesia looking forward to work very closely with all the signing members of the IOMED, and also China and also Hong Kong, in the following up of the establishment of the IOMED. So once again, thank you very much.
Thank you very much. The experience shared by our minister from Indonesia, from political settlement to trade disputes using mediation, is particularly insightful and important, I think, in current days as well, where a collaborative means have to be used. And if I may echo the fact that this fills a gap, because I think there is an institutional gap apart from litigation and media or judicial settlement or arbitration. Mediation needs an institutional gap, and we hope that the International Organization for Mediation will serve its role in providing filling that institutional gap, and thereby providing this alternative to the community. So if I may now turn to our next speaker, Dr. Danilo Turk, the former president of Slovenia. In fact, Dr. Turk visited Hong Kong, at least I remember, in October last year, where in his capacity as a member of the Interaction Council, came and visited, and we met Dr. Turk in the Asian Academy of International Law here in Hong Kong. And it was a very interesting discussion. We learned a lot then, and I'm very pleased that we are able to learn more from Dr. Turk, who will be giving some comments, I understand, on the text of the convention. So, Dr. Turk, please.
Well, thank you very much, Madam Chairman. What I would like to explain is that after having read the text of the convention and listened to speeches this morning, I came to the conclusion that actually the most important, most relevant aspect of my previous work has to do with the United Nations. I served as Assistant Secretary General for Political Affairs with Kofi Annan for 5 years between 2000 and 2005. And much of my work at that time, and much of course, primarily Kofi Annan's work, was related to one form of mediation or another. Nothing, and mediation does not always end up with a conclusion or with a clear conclusion. It leads from one process to another, And the hope is that improvement comes as a result of rather complex set of events that follow in that process. Now, in the spirit of that, and after having listened to the discussion and speeches earlier today, I would like to make 4 points. First, I would like to emphasize that the Convention on the Establishment of International Organization of Mediation is an extremely important step forward, because mediation is a widespread practice in diplomacy, but it needs a framework, and the Convention offers such a framework, hopefully leading to an organized practice in the future for the benefit of the international community as a whole. And it would be important in this context to study the experience of various organizations that have been involved in these activities, including in particular the United Nations with its large number of special envoys, special representatives, who on behalf of the Secretary General did deal with a variety of international disputes. That's a great and rich practice, which is not only characterized by successes, but it does bring a lot of important experience that has to be studied and made good use of. So that's my first comment. My second comment relates to the need for encouragement. Mediation is something that needs to be encouraged. And that too is not a new phenomenon. Actually, this is a very old phenomenon. The first international convention in this regard, the Hague Convention on Pacific Settlement of International Disputes of 1907, contains a clause in its Article 3, Paragraph 3 of the Convention, which says that offering mediation or good offices can never be interpreted as being something negative. It is said that offering mediation can never be regarded by one or another party as an unfriendly act. Now let us think about that provision for a while. For parties in a dispute between states, it's not easy to accept mediation. It's always very sensitive, and politically it may be complex. But I think the international community should be aware of the original idea of multilateral arrangements for mediation, which is based on this very simple principle. Parties to the dispute must not take the offer for mediation as an unfriendly act, quite to the opposite. So this is my second point. My third point relates to something that comes as a result from observing a particular process of mediation which took place in the first half of 1990s during the war in Bosnia and Herzegovina. The mediator who actually helped ending that war, the American diplomat, late Richard Holbrooke, after having gone through that experience, said something very important. He said, mediation is not like a formal musical piece, like a sonata or symphony or something of that sort, which has clear rules of composition. It's more like jazz. It's a variation on a theme. You have to improvise a little bit. You have to try. You have to do different things. And I believe that that need for flexibility of mediation and knowing that results are not necessarily come as a result of a single move or a single effort is something to keep in mind. And the International Organization for Mediation should develop that flexibility to new levels, experimentation, jazz-like effort to make sure that disputes are dealt with effectively and eventually resolved. And my fourth and last point relates to the need to have mediators who are qualified persons. That's something the Convention on Establishment of International Organization for Mediation speaks about. Now, qualified persons, and that's really a very important clause, and it requires further thought of what does it mean to be qualified for such a role. Well, it means many things. It means knowledge, of course, understanding of the problem, the politics of the problem. because disputes are not necessarily only about claims, opposing claims of the parties. If that was the case, it would be more appropriate to take adjudication as the approach. Very often, disputes are not so much about opposing claims as they are about tensions, about something that has accumulated over longer periods of history and where there is no simple and rational outcome. You have to handle things carefully, again in the spirit of jazz, as Richard Holbrooke once explained. So that's one thing which I believe has to be part of the understanding in the choice of qualified persons. The criteria for that should not be unduly rigid. They should be sufficiently flexible to allow this kind of understanding. Now, I would like to mention that Minister Ogresono just now spoke about the Aceh situation. I have followed that situation quite closely when I was working for the United Nations. And obviously, there has been an effort to address that situation by various actors, including by an organization based in Geneva called Humanitarian Dialogue, which took the humanitarian angle to see how best they could help. And they developed a number of ideas of how that could be done. And then after tsunami in 2005, all of a sudden, the situation became ripe for a serious effort. And that was the moment when Martti Ahtisaari came in, and Martti Ahtisaari was the right person for the job. But that was done on the basis of previous experience, which went for several years, which included a number of highly qualified people who were exploring the ideas and made proposals on how to deal with the issue. And obviously that has to be kept in mind. There has to be a capacity to study the situations, to look into what kind of people, not only from the state parties of the convention, but perhaps elsewhere, could be useful, and so forth. And very importantly, one should not have an illusion that things relating to a dispute settlement can remain secret. They are sooner or later becoming public, and then, of course, the capacity requires also dealing with the media, public aspects, social media nowadays, and so forth. So, to conclude, I would like to say the International Organization for Mediation has a very interesting future, a rich one, I'm sure, and I'm glad that I was invited to say a few words on this occasion today to mention some of the experience from the past which might, I believe, be of some usefulness for the future. Thank you very much.
Thank you very much, Dr. Tuk, to put our work in this panel into a musical session, which is extremely nice. Jazz is nice. Jazz is where you can, as you quite rightly observe, where there's a theme and then you flow with it in order to get to a lovely piece of music. And the same, I think, quite aptly said by you, is true for mediation. And interestingly, I think from that we learn how the rules are to be drafted. I myself, together with my good friend Dr. Gaston Canfec, are drafting or helping to draft the rules for the international investment and commercial set of rules. And so we will try and make it more musical and jazz-like in our future. And I think the suggestion of how mediators should be prepared and be with the right authority to resolve the disputes is also very important. I think the skills is one thing, but also the authority and the trust, as well as the impact that the person have on the parties is also very important. So thank you very, very much, Dr. Tuk. Now, we then move from a musical mediation, if I may, to perhaps a little bit more formal, because we're going to ask Judge Al-Kasana to share with us some of your views of mediation in the capacity that he has and the experience that he has. He's the former Deputy Prime Minister and former Minister of former Vice President, I should say, former Vice President of the International Court of Justice and former Prime Minister of Jordan. He has been sitting in the court since 2000 to 2011, and then as Vice President in 2006 to 2009. So, Judge, please, can you share with us your views?
Thank you. Thank you, Madam Chairman. May I start by saying how delighted I am to be back in Hong Kong, and how this most vibrant and cosmopolitan of all cities, and how honored to be addressing this distinguished group. Madam, I hope you wouldn't mind very much if I were to strike a discordant chord by speaking not extemporaneously, but reading from a little speech I had prepared. And of course, I'll be more than happy to respond to questions or to engage in further exchanges with my colleagues on the panel. So if I may do that, I will start by saying that the International Organization for Mediation is a welcome entrant among the organizations of the international community. Its very existence contributes in a timely manner to underscoring the at times overlooked importance of non-judicial forms of dispute settlement. Although it is sometimes forgotten, steps of a political or diplomatic nature, such as direct contacts, negotiation, mediation, have always been vital elements in the practice of peaceful settlement dispute settlement. The International Court of Justice has emphasized that recourse to arbitral or judicial means is, in the final analysis, simply an alternative to direct and friendly settlement by the parties. International law privileges the direct contact between parties, such as in negotiation and mediation, over binding third-party settlement through arbitration. There is, as the Secretary General of Exit recently observed, a significant increase in investment agreements that make provision for mandatory or optional mediation. China's representative in the Security Council, Ambassador Liu Zhenmin, was entirely correct to recognize in 2008 that mediation is an important instrument for the peaceful settlement of disputes. Madam, Article 33, Paragraph 1 of the Charter of the United Nations enumerates the different means of dispute settlement, beginning with the vital, most direct means and moving gradually towards the least direct means. Article 33, Paragraph 1 provides, and I quote, "The parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice." This is the context in which we need to understand and situate the topic of mediation. All we know when relations between the parties are not or no longer conducive to direct negotiations, the intervention of a third party may be of considerable assistance. Mediation consists in the first instance of bringing the protagonists to a conflict together, but it does not end there. The mediator actually intervenes to the negotiations as they develop and is authorized to follow and even to guide the negotiations to their conclusion. Article 4 of the 1899 Hague Convention for the Pacific Settlement of International Disputes describes the role of the mediator well. It states, and I quote again, "The part of the mediator consists in reconciling the opposing claims and appeasing the feelings of resentment which may have arisen between the states at variance." Unquote. Senior British diplomat Sir Emmer Jones Parry has described mediation in these terms, and I quote again, "Usually action is by a third party of particular standing or reputation who seeks to bring about, initiate, or secure the continuation of negotiations without necessarily themselves participating in the negotiations." It is not difficult to find historical examples of successful and helpful mediations. In medieval England, mediation, or settlement by love, as it was then called, was greatly encouraged by King Henry I. In fact, English judges would often adjourn cases between private parties so that a mediated settlement could be reached instead. A famous example is when the Republic of Venice, acting as mediator, brought to an end the war between Germany and France, the outcome of which was the Treaty of Munster of 1648, the Peace of Westphalia. A respected Venetian diplomat had been chosen to act as mediator between the parties. The parties gratefully recognized his efforts in the preamble to the final treaty, which had praise for, and I am quoting again, "the mediation and interposition of the most illustrious and most excellent ambassador and senator of Venice, Aloysius Contarini, knight, who for the space of 5 years or thereabouts, with great diligence and a spirit entirely impartial, has been inclined to be the mediator in those affairs." I propose to look at 4 more representative examples, which say something about what can be achieved through the instrumentality of mediation. First, the successor of Count Volker Bernadotte, a United Nations mediator in Palestine, Ralph Bunche, mediated on the Mediterranean island of Rhodes between Israel and the Arab neighbors for an armistice agreement in 1948-1949. The mediation lasted 42 days. The mediator held preliminary discussions separately with each delegation on each substantive item. Then informal meetings were arranged between the heads of delegations and the mediator. When discussion on the item had reached an advanced state, joint formal meetings were held. Crucially, the mediator organized the negotiations such that it was not clear to the world whether the two sides actually met directly or through the mediator. This successful use of deliberate ambiguity has since been referred to as the Rhodes Formula. The example brings out the flexibility of mediation and when can it be achieved when the right person is appointed as mediator. Second example is the World Bank, when the World Bank acted from 1952 to 1960 as mediator in the Indus Basin dispute between India and Pakistan, which after intense negotiations led to the adoption of the important Indus Water Treaty. Judge Baxter explained in a study of his mediation that the World Bank's function actually went beyond that of a mediator. He said, as the real differences were brought to light, the bank was forced to play a more active part in working out a solution. The bank pursued its own inquiries into the facts, and it was the bank which at various stages suggested principles upon which the agreements might be based, a process which might be described as continuing conciliation. Judge Baxter concluded that the wisdom to be derived from the example was that if a constructive solution is to be worked out, something more than good offices or mediation by a third party may be required, and that the disputants should be prepared at the outset to entrust a third party with a number of exchanges with the parties. No progress was made. The Secretary General, whose judicial settlement by the International Court of Justice as the means of the solution of the controversy. The case is pending before the court. Here too, we see mediation working in combination with other forms of dispute settlement. To conclude, what are we to make of the merits and demerits of international mediation? Almost 100 years ago, an experienced moderator and statesman, Francisco de la Bata of Mexico, wrote of mediation that, and I quote, "The pliability and flexibility of the institution are well suited to the needs of today's world, and the speed of the procedure is well suited to the needs of modern life." More recently, Blaise Godet, I'm about to finish. I'm sorry, it took longer than. Formerly ambassador of Switzerland to China, cautioned that although flexibility is an undoubted advantage, the inconvenience is that the mediator might be tempted to promote its own interests. This is among the aspects of mediation that must always be kept in mind, but as we have seen, it is far from insuperable difficulty. Joseph Stalin once said, perhaps tongue-in-cheek, that sincere diplomacy is no more possible than dry water or wooden iron. Whatever we think of Stalin's cynicism as regards diplomacy, I for one remain convinced that sincere mediation is eminently possible. Indeed, successor Venice's mediation of the Peace of Westphalia was attributed to the Venetian mediator possessing, according to the parties themselves, a spirit entirely impartial. The importance of neutrality and fairness has been stressed more recently as well, as China correctly observed in a meeting of the Security Council in 2008. Facts have shown that neutrality and fairness constitute the basic conditions for successful mediation. In the presidential statement that followed that meeting, the Security Council rightly emphasized the importance that mediators should be experienced, impartial, have a good knowledge of all the stakeholders, facts, and circumstances of any dispute to which they have been assigned, and are provided with the necessary support and flexibility to approach mediation according to the specifics of the dispute. That is the lesson history teaches us at the present context of mediation in the field of investor-state relations as well. As Lord Neuberger, President of the Supreme Court of the United Kingdom, has observed, striking the right balance is fundamental for mediation to work successfully. What that right balance is struck, however, mediation works as a vital adjunct to litigation. In this context, the International Organization for Mediation, based on the sensible balance struck in its founding convention, is a most welcome newcomer on the international scene. I am grateful for the opportunity to come to Hong Kong to wish it and its parties every prosperity and success. Thank you very much for your attention, and I apologize if I took more time than I should have.
I apologize for having to pass you a note, but thank you very much, Judge, sharing the experience of mediation, and perhaps for those of us who are doing mediation to get the lessons learned from those examples. If we may now then turn to Professor Dr. Surakriyat Sathirate, former Deputy Prime Minister and former Minister of Foreign Affairs of Thailand. He is also the chairman of the Asian Peace and Reconciliation Council, who actually has a lot of experience to share on how, in a very quiet, I believe one would describe, and behind-the-scene way, help to resolve disputes through a reconciliation process. Professor Dr. Surakriyat, please.
Thank you very much, Secretary Teresa Cheng, Secretary Paul Lam, Her Excellency Minister of Commerce of Cambodia, and Excellencies, ladies and gentlemen, friends. It is indeed my greatest pleasure to be invited to witness the signing ceremony this morning and to be with all of you on this global forum. First of all, Teresa, I have to congratulate all of you for the establishment of the International Organization of Mediation in Hong Kong. To me, Hong Kong has reputation, a very positive one, a world-renowned legal infrastructure and judicial system. Hong Kong has an international reputation for being center for various dispute resolutions. And Hong Kong has excellent personality with international reputation. Professor Teresa Cheng, former Secretary of Justice, is one of them. And congratulate, in retrospect, your establishment of the International Academy of International Law. I think Hong Kong, of course, is well positioned to host this headquarters of International Organization for Mediation. It's good that this international organization, because I think what is needed to have an organization like this is that the organization has to be able to build confidence. So I think that the process of establishing this organization is part of the confidence building process for everyone in the world to have confidence in this center. I think the key success to the International Organization for Mediation is the fact that it has to show to the world that the center, that the organization is independent and also is very impartial. So I think independence and impartiality would be the driving force of the IOMED. In the world that we have seen a lot of bilateralization or unilateralization of multilateral issue, the establishment of the IOMED is a part of what I call the multilateralization of unilateral issue. I think it's important that all of us in the world, we have to do the reverse, because the multilateral institutions and multilateralism have been, I would say, undermined, if not destroyed. So perhaps based on or reference to Article 33 of the UN Charter, IOMED can be a brick building to a new global order after the past global order has already been shaken to a large extent. Excellencies, ladies and gentlemen, I think we need to understand the nature of the conflict, either interstate, intrastate conflicts between state and non-state actor, and multi-state conflicts like we have in the South China Sea. Many of these conflicts are deeply rooted, very intractable, very complex, and very multifaceted. Oftentimes, positions are very far apart and entrenched, and the parties concerned are not ready to engage in direct talks. So I just would like to share with you briefly experience of the APRC, the Asian Peace and Reconciliation Council, which is a non-state international organization that we launched in 2012 and I've been the chairman since then. APRC is a non-state international organization consisted of former policymakers. We have former president, former prime minister, former ministers from various countries in Asia, including some countries in Europe. We have an academic, and we have a leading business person from Asia joining the group. Because for us, peace belongs to everyone. Peace does not belong only to diplomat or to policymaker. So we have to culture and nurture the culture of peace and reconciliation among various groups of people. Third-party mediation is an often used diplomatic tool to help are done by states, such as the role taken by the United States in the war between Russia and Ukraine, or perhaps by non-governmental organizations such as APRC. What I call the work of APRC is that it's a track 2 diplomacy. Track 1 is governmental relationship. Track 2 is non-governmental. But track 2 diplomacy is often deployed because it provides a safe space for mediations in order to facilitate informal dialogue whereby parties to the conflict can go beyond the official positions. We can probe various ideas, and as we have found since 2012, parties concerned are more eager to express ideas that they would not otherwise express through formal diplomatic channel. We can exercise flexibility as much as possible so that we can understand each other's concerns and interests and to be able to find common grounds if possible. The philosophy and approach that APRC has always adhered to is, as Teresa has said, is a pursuit of a quiet diplomacy, behind the scene, and impartial diplomacy. We don't mind if parties to the conflict, we say that, there are meetings between APRC Council members and the parties concerned, but we ourselves will not solicit. We don't need public recognition. We don't need public fanfare, but we do it impartially and through the quiet diplomacy. APRC has no agenda than helping the parties to the conflict bridge their differences. And in doing so, I have to say that we are often in the listening mode. Oftentimes, I call my trip to meet various policymakers as a listening forum, trying to better understand the fundamental concerns and interests of each party, identifying areas of divergence and convergence, after which we may offer our advice and recommendations. So many times we are able to bring sincere concern of one party to the other, and maybe one party have said to us that this is exactly what we would like to, this is exactly the message that we would like to deliver to the other side, but we don't want to offend the other side. So could you please carry this message to the other side? And we did it with a big country. And the big country have said also, oh, I didn't know that that's a big concern of that particular country, so that we can respond. I cannot go into so much details because it's supposed to be quite diplomacy and behind the scene. But as much as I can say that it has been proved quite successful. So the key is to build up trust and confidence. And it is something that I would like to share with IOMED. I think we may need to employ similar approach by having trust, confidence with parties to the conflict. Try to get them not to go outside, try to get them to go outside the comfort zone. APRC is well positioned in this regard because our council members comprise of former leaders who have experience in international diplomacy and understand the complexities and sensitivities of the issue. And the council members have held senior positions in the government before, so they have networked with people in the government. The APRC has done considerable work, which I cannot go in so much detail, but one of the issues that spent a lot of time in the past year is on the South China Sea. We are looking at, or we have looked at the agreement between Thailand and Malaysia. We have overlapping claim in the Gulf of Thailand. And since 1978, we have agreed to disagree. So we put the territorial delimitation on the shelf, and we tried to negotiate until we reached a joint development area of oil and gas. And since 1978, there's been no clash or no conflicts in the Gulf of Thailand between Malaysia and Thailand. Next, we did the same thing with Vietnam, and I hope that we can do the same thing with Cambodia in the near future on the overlapping area. So these are examples. In fact, there are over 30 examples all over the world where countries that have overlapping claims in so many areas because of the law of the sea have to enter into a provisional measures to agree on what to do, and then let international lawyers, expert in maps, continue with the negotiation maybe for the next 40 years. Because in territorial delimitation, no one can budge an inch, but we can turn conflict into cooperation. The other issue that we did was when I was appointed by Daw Aung San Suu Kyi to be the chairman of the advisory board on Rakhine State to see how Kofi Annan's recommendations can be implemented in the midst of intercommunal conflicts. So that's one of the work that we did through quiet diplomacy. And in the past 3 years until today, we've been working on Myanmar issue. We met 40 representatives of 40 opposition parties. We also met the government, and we're trying to see whether there is any common ground, whether there is any common denominator, or what ASEAN countries, we call it the lowest hanging fruit, and bring the message of one party to the other. It's important to analyze, to emphasize that mediation in the track 2 diplomacy is meant to complement efforts in the track 1. The effectiveness of the track 2 diplomacy and mediation depends significantly on the linkages and coordination between track 2 and track 1. The two tracks need to converge in order to produce tangible progress. Teresa, APRC would be most happy to be working with IOMED to share experience and to supplement work of IOMED that is probably track 1, but international, so that peaceful dialogue can take place and rule of law is upheld. Thank you very much.
Very much. Thank you very much. Thank you for the sharing. And I'm sure that the International Organization for Mediation would love to work with organizations elsewhere in order to develop a pool of qualified mediators, as well as to continue to do capacity building and sharing of experience. So thank you very much. The track 1 and track 2 need to converge to produce tangible progress. And I think that's a very, very wise words. If I may now then turn to our next speaker, Judge Abdul Karoma, formerly the member of the International Court of Justice, judge in 1994 to 2012, and he is now a judge ad hoc also of the ICJ. And I believe Judge Karoma is going to share with us some of your views on how mediation actually can work in the experience that you've had in judicial settlement. Thank you, Judge.
Thank you, Madam Chairman. Your Excellencies, distinguished participants, I would first of all like to express my profound gratitude to the government of China and to the authorities here in Hong Kong for inviting me to participate on this occasion. In a way, the establishment of the mechanism on international mediation is a personal fulfillment. I was, for many years, in the 70s, 80s, and 90s, the permanent representative of my country to the United Nations in New York. And there used to be on the effectiveness of the United Nations and the role of the organization. That was a time when, unfortunately, the United Nations was not performing the role that was expected of it. There were so many disputes which were not being resolved, even though one of the fundamental objectives of the United Nations is the peaceful settlement of peace. So in those days, we lamented the fact that the United Nations was not functioning as it should. And then after the United Nations, during that time, we worked on what became known as the Manila Declaration for the peaceful settlement of disputes. I dare say here, we are in Manila in those days under the Foreign Minister of the Philippines, late General Romulo, and those were the days before the internet, and we succeeded in adopting the Manila Declaration on the peaceful settlement of disputes. That also included mediation. My lamentation was when I joined the International Court of Justice in 1994. I noticed that disputes were being brought to the court to be litigated that could have been better addressed in a forum of mediation. It would have been more effective. But you know what happened? Agents, particularly, not all, of many developing countries were not equipped technically to conduct their cases. And their counsel, their lawyers, took over their disputes, and for reasons best known to them, would prefer to litigate such disputes instead of using mediation as a forum for finding a peaceful solution to such disputes. Now, the title of this afternoon's proceeding is International Mediation Between States. Mediation serves as a process or a mechanism for the peaceful settlement of disputes involving the participation of a neutral third party with the aim, of helping parties to reach agreement. I repeat, mediation serves as a process or mechanism for the peaceful settlement of disputes involving the participation of neutral third parties with the aim of helping the parties to the dispute to reach an agreement. And the chairperson commented earlier on that in the choice of the members of the mediation, they must be competent. When you are composing the mediation commission or whatever you call, now we have a forum for mediation. It is not just to appoint everybody. The mediator should be equipped technically. She should know the nature of the dispute and should have the applicable skills and to be able to encourage the parties to reach an agreement. So that is fundamentally important. The composition of the mediation commission should be looked at very carefully before the mediation itself is constituted. There is not much of a difference between mediation and conciliation. As many of you might know, I recently had the privilege of participating in a conciliation commission between Timor-Leste and Australia. And there is not much of a difference, I repeat, between conciliation and mediation. And if we were able to solve that dispute between a developing country and a developed country, it shows that the time for mediation has arrived. And we need not make an apology for that. But what has been happening in the past, as I repeat, I'm not castigating agents who were not equipped to advise, to instruct counsel, would have rather litigated such a dispute. And at the end of the day, it was time-consuming, more expensive, and it leaves the party at loggerheads. Now, I would just would like to return to the topic as I have been asked to do, to speak on mediation as a method of peaceful settlement of dispute. The peaceful settlement of dispute, as you all know, is a foundational principle of the United Nations Charter, enshrined in the articles of the Charter, according to which states are obligated to settle their disputes by peaceful means in such a manner that international peace and security and justice are not endangered. Article 33 of the Charter lists negotiations, inquiry, mediation. I repeat, it's in the Charter. Mediation, conciliation, arbitration, and judicial settlement. So we need make no apology for the establishment of the mechanism of mediation in this forum. It is part of the United Nations Charter, and it has been practiced and has been, as in the past, proved effective and efficacious. While arbitration and adjudication involve structured legal processes with binding outcomes, mediation often operates in parallel to or in preparation for these formal methods, providing a pathway for compromise or de-escalation and consent-based resolution. Those are some of the advantages. Mediation complements these formal methods of arbitration and litigation, of resolution, and enhances the legitimacy, the efficacy, and sustainability of formal state dispute resolution. Now, most of the disputes that come before international tribunals are by neighboring states. And irrespective of the outcome, the decision, you have to live together. You can't choose your neighbor. And you would like to arrive at a decision that would encourage you to continue to live together amicably. And that is one of the advantages of mediation. The key features of mediation are well known. It is a process in which a third party facilitates negotiation itself. Negotiation itself is another means of dispute settlement between disputing states, with the aim of achieving a mutually, I repeat, a mutually acceptable solution. Unlike arbitration or adjudication, the mediator does not render a binding decision. However, the process carries legal value. When you come to the International Court of Justice, it delivers a judgment. That judgment is binding on the parties. The parties have no say in reaching the judgment of the ICJ. But in reaching an agreement under mediation, both parties play a role in reaching that agreement. And they will be prepared and able to live with such an agreement in the future. The recognition of the role of mediation is reaffirmed, as I said earlier on, in the Manila Declaration on the Peaceful Settlement of Disputes, which was adopted by the General Assembly of the United Nations in 1982. The declaration encourages states to mediate their disputes at all stages. Additionally, the declaration is frequently referenced in bilateral and multilateral treaties as a preferred initial step before escalation to arbitration and judicial forums. So, though lacking binding force, I'm talking about mediation now, mediation as a mechanism for the settlement of disputes could ultimately lead to binding outcomes, such as treaties or memoranda of understanding that are subject to international law once signed. The mediation process itself is not oblivious of taking into consideration international legal principles. Otherwise, it will not have the efficacy that is expected of it. If a mediation award or whatever agreement is legem is contrary to law, the parties themselves would not accept the outcome of a mediation process. So I would like to emphasize here that though the process itself is not binding as such, the outcome, not the process, is not binding as such, but it has legal consequences which cannot easily be ignored. For example, the United Nations Convention on the Law of the Sea, UNCLOS, encourages states to attempt mediation, yes, before invoking formal dispute settlement mechanisms. That is in Part 15 of the of UNCLOS. Similarly, the Energy Charter Treaty includes a conciliation and mediation phase prior to arbitration. The logic is then clear. Early stage mediation can resolve issues or clarify disputes, reducing the scope of later legal proceedings, or even avoiding them altogether. But even when mediation does not resolve the core issue, it can lead to agreement on procedural matters. For example, where should the mediation take place? It could lead to establishing the timetable or the scope of the dispute. The treaty practice also underscores the functional compatibility of mediation with formal legal methods and points to a growing trend of integrated legal design in dispute resolution. As stated earlier, the establishment of the International Organization on Mediation could not have taken place in a more significant and timely manner. Unfortunately, due to diverse historical changes in geopolitics and given the nature of the new disputes arising today, I think a better forum, a better process for resolving such dispute is through mediation. So this is a very timely process, a very timely mechanism which we are fortunate to have established here in Hong Kong. I say I don't have much time, but I'll try to summarize what I've been saying so far. Mediation, though inherently non-binding, plays a crucial role in interstate dispute settlement. It complements adjudication and arbitration by creating entry points for negotiation, narrowing issues, and it facilitates implementation and diplomatic relationships, even amid legal conflicts. Far from being an alternative to law, mediation often amplifies the legal mechanism, often offers a pragmatic route to the formal process of dispute settlement. As international relations have grown more complex and multipolar, as new types of disputes have emerged, the legal architecture of dispute settlement by states must continue to evolve, and that is what this, the establishment of the mediation has done today. The legal architecture for solving such disputes is evolving. So you need not make any apologies for the establishment of the International Organization for Mediation. It was overdue and its time has arrived. And it should be seen as a contribution to the enhancement, legitimacy, and durability of the peaceful outcomes or the peaceful settlement of disputes. I thank you for your attention.
Thank you very much, Judge Karoma. I think the settlement being a consent-based resolution enhances legitimacy is a very important point to bear in mind when one compares the benefits of mediation as opposed to other adversarial processes. Thank you very much. And if I may also echo one point about the lack of distinction between conciliation and mediation. I think there are still some people who would insist that they are actually different processes. In the convention itself, as I recall, there are provisions there to say that it doesn't really matter what you call it. Ultimately, it is in the very elements, as Judge Karoma and other speakers have mentioned, a third-party neutral, facilitating negotiation process, reaching a result that both parties or all parties are happy with, and then getting into an agreement, be they treaty, probably state to state would be in some form of treaty between the two states, or in a settlement agreement if it is in international settlement, commercial or investment. So I think let's not split hair about conciliation and mediation, split hair about some evaluative and facilitative mediation, look at mediation in the way that my learned friend Dr. Turk mentioned, look at it as a jazz, feeling in the right moves in order to get to a settlement. So thank you very much, Judge Karoma. So if I may now ask Mr. Xia Huang to do the next presentation. Mr. Xia Huang has a lot of experience, I think, working in Africa as ambassadors as well as working in the embassies there. He is now a special envoy of the United Nations Secretary General for Great Lakes region. Mr. Xia, please.
感谢秘书长，感谢 中国政府邀请联合国参加国际调解论坛，并且与各位前政要、各位专家参加今天下午的国家间争端调解研讨活动。联合国宪章开章第一句话就是“欲后世免遭战祸”，这是联合国的初心和使命。 自成立之初，联合国即将预防外交作为维护和平与安全工作的重点。今天上午，很多代表提到了联合国宪章第33条有关解决国际争端的各种手段和途径。联合国宪章还明确了联合国秘书长、 国家安全理事会和联合国大会在解决国际争端方面的作用。除了联合国秘书长亲自采取的行动之外，联合国特别是秘书长安理会的重要一个举措，就是任命特使和特别代表进行斡旋和调解。 联合国的秘书长和特使参与和平进程，同时领导联合国的政治特派团和维和特派团。在今天全球的22个政治特派团和11个维和特派团当中，有13个在非洲。维和部队 部署在非洲的维和部队总人数将近90%，这足以说明了和平与安全问题对非洲来讲是如何严峻，调解工作如何重要。2019年， 我被秘书长任命为大湖地区特使以来，我积极在地区国家之间开展斡旋和穿梭外交，支持地区国家和区域组织发挥主导作用，帮助大湖地区实现和平与稳定。我想在这里呢，通过我的切身工作呢，跟大家分享一点我的观察和思考。大湖地区的动荡危机已经延宕30多年，刚果金东部地区的危机尤为严重。这种动荡和危机是由国家和地区层面多重因素综合造成的。首先，在国家层面，刚果金国家治理不善，政府对东部地区掌控乏力，部族冲突频发，这就导致许多刚果金内部和外国的武装团伙趁虚而入，占据矿产资源丰富的地区。从地区层面来讲，某些邻国疯狂追求势力范围政策，追求掠夺刚金东部丰富的自然资源，其中一个重要手段就是向刚东地区，不管是刚果金内部的还是外国的武装团伙，提供支持，为自己的势力范围政策和资源掠夺提供保障。这也就导致了刚果金与邻国之间频繁的政治和外交紧张局势。2021年11月，一个非政府组织 M23东山再起，重新燃起了大湖地区大规模的战火。今天大湖地区面临的是比10年前更为严重的一次政治和安全危机。这次危机出现以后，大家频繁听到内罗毕进程、卢安达进程，非盟最近又任命了多个总统，弗雷作为新的调解人。作为联合国，我们积极支持这些进程，与各个调解各方分享联合国在调解方面的经验，提供行政后勤支持，同时协调联合国的各个机构和国际合作伙伴，调动资源，为有关的和平进程提供资金支持。这次危机出现以后，2022年2月、2023年5月，以及今年的5月28号，我们已经连续举行了多次峰会。从目前来讲，这些调解虽然取得了一些成效，但是目前的努力远不足以结束当前的危机，远不足以保证大湖地区能够走出延宕30年的持续动荡。最近这几年的观察，我们认为有几个方面值得注意。第一，任何调解都必须 从各方之间的坦诚对话开始，并且需要持续解决冲突的政治意愿。遗憾的是，在大湖地区，坦诚和信任是稀缺资源，政治意愿也不足以保证结束当前的危机。此外，对各方的核心关切要有明确的定义，包括最敏感的问题。在调解的初始阶段，对和平问题的模糊处理，极易造成误解，从而使调解工作复杂化。第二，应将调解工作委托给具有相应手段和资源的专职人士。目前的危机调解过程当中，往往是由一些现职的总统和部长来亲自主持，这些重要的人士难以集中足够的精力，保证调解能够顺利的进行。同时，调解要有明确的授权，以便从授权一开始，以便从调解一开始就明确路线图和目标。只有在全职人士全面调解之下，才能保证每次会议能够取得充分的效果。第三，我们认为现在的调解应该更广泛，应该有更大的包容性，充分听取妇女、青年和不同群体、民间社会的意见。第四，调解进程是否真实有效可信，很大程度上取决于是否拥有独立的监督机制，并能够对违反承诺的行为进行有效惩罚。遗憾的是，自98年以来，大湖地区签署了多少个文件，确定了多少个机制，目前没有任何一个独立的有效的监督机制，也没有任何有效的对违反承诺进行惩戒的措施。第五，必须建立与国际合作伙伴的协同机制，以便更好地能够协调工作、共享信息、调动资源，并在危机发始之初就及时作出预警。目前这些调解工作还在继续，围绕这几条，我们在跟调解各方频繁接触，希望他们能够在总结过去经验、吸取教训的基础上，使今天的调解工作能够取得更大的成效。我们衷心希望国际调解院能够与现行的国际争端解决机制协同增效，为高效和平化解国际纠纷提供更多的选择和途径，也希望能够为大湖地区实现和平与稳定提供支持和帮助。谢谢各位。
Thank you very much for sharing the experience in the African regions and the various points that have been made about suggestions on what a mediation should bear in mind in future. Thank you very much. If I may now turn to Judge Gao Zhiguo. Judge Gao is the former judge of the International Tribunal for the Law of the Sea, and he's going to share with us some thoughts on the IOMAT. Judge Gao, please. I hope I am not going to have to trouble and pass you a paper to watch the time, because I think we are now transgressing into the tea time already, but I think we will continue to want to listen to all the wise speeches and wisdom that you are going to be sharing. Judge Gao, please.
Thank you, Teresa. Your Excellencies, distinguished delegates and participants, ladies and gentlemen, good afternoon. I wish to thank the government of Hong Kong, SAR, for including me into the program of the Global Forum on International Mediation. It is my great pleasure to witness, together with you here in Hong Kong, the signing of the convention and the creation of the International Organization for Mediation. Dispute resolution is one of my favorite subjects. And actually, I prepared a relatively long speech. But due to the time constraint on presentation as instructed by the moderator, I will skip the majority part of my paper and move very quickly to the few final paragraphs. It becomes increasingly evident that international mediation will assume a more prominent role in the settlement of international disputes. The signing of the convention, as well as the creation of IOMED itself, represents a timely and constructive response to current global needs and constitute a meaningful step towards the promotion and maintenance of international peace. I therefore wish to flow a few observations and comments on the current development of international organization for mediation. First, the signing of the convention and creation of the organization have profound implications. Its political significance may lie in the following facts or aspect. The fact that IOMED is a public good created by the Global South countries. As His Excellency Chinese Foreign Minister Mr. Wang Yi said in his invitation letter to us, I quote, "The IOMED will be the world's first international legal organization dedicated to international dispute resolution through mediation, a public good on the rule of law from Global South countries," unquote. IOMED, jointly launched by China and like-minded countries, represents a new paradigm of international collaboration in the field of Pacific settlement of international disputes. Second, IOMED is of also legal significance. The creation of a permanent, independent body of international mediation certainly represents a concrete step in the progressive development of international law. International mediation has traditionally been sporadic and proceeded on a case-by-case basis. So the creation of an international organization for mediation fulfilled the goal of institutionalization of international mediation. Such a task, as Judge Kuroma mentioned a few minutes ago, has been long overdue. Third, some may express concerns that the establishment of a permanent international organization for mediation could lead to fragmentation in international jurisdiction and practice. However, our view is that IOMED is only complementary in nature, rather than the substitution of the existing international dispute resolution mechanisms. IOMAT will serve as an important and valuable complement to the existing international dispute resolution mechanism and provides a new option for countries to settle their differences and disputes. Fourth, another issue confronted by IOMAT is the need for substantive and procedural rule building. Therefore, the development of substantive rules, clear procedural guidelines, ethical standards for moderators, rule governing enforceability and confidentiality, etc., is essential for the next steps. Last but not least, it is the issue of institutional value of international organization for mediation. It offers a flexible and less adversarial alternative, and especially valuable in situations where judicial proceedings are difficult to initiate or entail prohibitively high cost. In the final analysis, IOMAT's value and validity depend on cases. I mean, case submission and case handling. To this end, we look forward to the first submissions of cases to the organization in the near future. In the final conclusion, I wish to highlight that the collective endeavors by the contracting parties over the last few years in the successful institutionalization of international mediation would contribute to bring us one step closer to international peace and security, and one step further towards a community with a shared future for mankind. This brings me to the end of my presentation. Thank you.
Thank you very much, Judge Gao. A very wise observation about the establishment of the IOMAT is like a renewed commitment to peaceful settlement of disputes. I think it's very important that we continue to remember that very important point of the establishment of the IOMAT. If I may now then turn to Mr. Puja, the Executive Director of ASEAN Institute for Peace and Reconciliation, and he has some experience that he will be able to share from the ASEAN perspective, and we look forward to hearing from you. Mr. Puja, please.
Thank you so much, Prof, and thank you for this opportunity. I'm certainly privileged among distinguished and inspiring speakers and panelists this afternoon. We are fully aware that mediation is a complex process of turning conflict into peace. Dr. Daniel Turk mentioning about this is like a jazz process, but for my own experience, 5 years working with Martin Griffiths and with late President Marty Atesari later on, so I feel it's like a combination between jazz and rock and roll. But sometimes it's up and sometimes it's really down, and just like a roller coaster sometimes. Well, the structures within which a mediator seeks to facilitate the mediation between conflict parties can vary considerably. No two conflicts are exactly alike. No one-size-fits-all models. Each situation demands its custom-made resolutions. What matters actually is not who does it, but the fact that conflict is resolved, lives are safe, and no more sufferings. As the former UN Secretary General Kofi Annan said, that I suspect that this quote composed by Dr. Danilo Turk before. I quote, "Successful mediation and the ability of a mediator to influence and guide the process depends on a wide range of contextual factors, such as the comparative strengths of the parties to the conflicts, their perceptions of the way the conflict is moving, their state of exhaustion or fresh hopes, the support they are getting from various external forces, including from the key elements within the international community, and certainly good luck." My observations: first, mediations can succeed only if there are sufficient measures of trust between the two parties and sides. Second, much of the progress of the peace talks at any given time could be attributed to the way the negotiations and mediations were organized and prepared. Third, communications efforts aiming at forming a wide-range constituency for peace by keeping the doors of all inclusive dialogues open. Fourth, engaging in diplomacy and work cooperatively to generate a win-win options. China brokered an agreement between Iran and Saudi Arabia in March 2023, astonished the world by achieving an unexpected diplomatic breakthrough that reshaped the world order. This is a game changer. Now, let me touch a little bit upon ASEAN and mediation efforts. ASEAN member states have taken some best practices of preventing, mediating, and resolving conflicts in the past. For example, ASEAN's management of the conflict between Cambodia and Thailand over the area surrounding the Preah Vihear temple in 2011 has been considered as unprecedented. This crisis provided a litmus test not only of the Indonesia chairmanship of ASEAN in 2011, but also of ASEAN's capacity to peacefully manage the potential of conflicts among its member states. A chair of ASEAN, Indonesia's good office's efforts was only possible because it enjoyed the trust and confidence of the conflicting parties in terms of its impartiality and objectivity, strike the right equilibrium for certainty on the way forward, and at the same time, show flexibility of actions. The lesson we learned from this case that ASEAN must seize the initiative addressing emerging issues affecting its member countries, shaping and molding developments, and not allow such issues to spiral out of control. Also, to give sufficient diplomatic space for the process to take course without any time compromising their respective national principal position. Certainly, to ensure that leave no stone unturned in searching for a peaceful solution. To conclude, mediation should touch upon this complexity and the root causes by listening voices and grievances those affected by conflict. How to bring people together and talk to each other. What incentives to be granted for conflicting parties to sit together. Mediator should be, as mentioned before, trusted, credible, and knowledgeable. He or she should know how to lead the process and prepare the unexpected. It is, of course, including and also promoting the role of women under the WPS agenda in peace processes. It is said that what humans started, human can end. All conflicts must be resolved. And an inclusive dialogue can create conditions for sustainable peace. And of course, it takes two to tango. I said that, I quote, a successful conflict mediator needs the skills of a chess master to play each side off against the other while moving them towards an end in which both sides can claim victory. For the most part, mediators work behind the scenes quietly and with the full knowledge that success will bring praise for the parties and failure blame to the mediators. We have to be responsive and forward-looking and able to anticipate opportunities and addressing emergencies and future challenges of this current fragmented and disruptive world. The establishment of this international organization on mediation is certainly a breakthrough. Hope it becomes a game changer. I thank you, Prof.
Thank you very much. I think the observations are particularly apt, especially in the Asian region, where mediation is a very useful dispute. I particularly note the phrase, "it takes two to tango." We are really becoming a musical gathering with the two parties tango, and the mediator will do the jazz music that makes everybody very happy. I think that's a very nice scene to look forward to. But finally, let's get serious again. If I may now invite Mr. Boris Keller-Sivik, the Deputy Head of the International Committee of the Red Cross, Regional Delegation for East Asia, to share us your views, please.
Good afternoon. Thank you very much. At the end of this session, of course, we will share a few elements from the perspective of the International Committee of the Red Cross, the ICRC. I represent the regional delegation for East Asia in Beijing. First, we would like to thank the insightful exchanges we had with the preparatory office for IOMED over the past year, and we are really grateful to be present here for this distinct occasion. So when we talk about the ICRC, as I said, I will say three things. Of course, a somber reminder of the state of things in our domain, in the humanitarian action. We will express hope. I think today we need to hope also with what is happening in this room and what will follow, that we hope to see more action to reduce conflicts. And the third element is the responsibility. The states are finally those who need to make action and really support the process going forward. So allow me 5 minutes, and we'll be happy to share afterwards with some of you. A reminder of the state of things. Today, the ICRC is present in more than 90 countries around the world, delivering much-needed services to those affected by armed conflicts and violence. The average length of ICRC presence in its 10 largest world operations is more than 40 years. And as of 2024, there were more than 120 ongoing armed conflicts around the world, causing severe humanitarian and environmental consequences. Today, the number of armed conflicts and cycles of violence are increasing, yet the humanitarian space is rapidly shrinking. On the occasion of the 75th anniversary of Geneva Conventions last year, ICRC President, Her Excellency Mirjana Špoljarić asked, "Where are the peacemakers? Where are they? Where are the men and women leading the negotiations that will bring wars to end?" I too have wondered the same thing while experiencing the conflict in my own country for 4 years, Bosnia and Herzegovina. Dr. Turk mentioned this in the 1990s. And the same questions, where are the peacemakers, unfortunately strongly echo today. And while waiting for the jazz to happen, I must say that observing on the ground, it's more the music of funeral march that happens before the mediation takes place. And now for the hope. The establishment of the International Organization for Mediation may offer hope, as there may be a forum where armed conflicts could end through mediation, or humanitarian agreements might be brokered to alleviate human suffering during armed conflict and violence. A forum where dialogue can ensue and armed conflicts and violence may be prevented altogether. A forum where potential peacemakers and negotiators can speak up against the disregard for international humanitarian law and against human suffering. In September 2024, the ICRC president, together with states of Brazil, China, France, Jordan, Kazakhstan, and South Africa, launched a global initiative to galvanize political commitment to respect of international humanitarian law. The initiative seeks to overcome political divides and stalemates, if only for the sake of restoring a minimum of humanity in war. Through dialogue and political will, it is possible to mediate disagreements peacefully without resort to armed force and engaging in protracted cycles of violence. With many states around the world joining the initiative, we hope that all member states of International Organization for Mediation and others will also join the initiative and promote its aim. Championing humanity and galvanizing political commitment to IHL is a collective effort. The Global IHL Initiative focuses on 7 thematic streams, one of which is IHL and peace. This work stream focuses on how respect for IHL can create an environment conducive to peace. The work stream explores the relationship between IHL and peace negotiations, how respect for IHL facilitates peace by preventing violations that fuel conflict, and likewise, how peace negotiations must consider IHL obligations to ensure durable and lawful resolutions. Mediation forums have the power to promote and implement IHL compliance. This year, the ICRC turns 162 years, and one thing is for certain: the world today is no longer the same world of 1863. At that time, the majority of conflict casualties were combatants. Today, the overwhelming number of casualties are civilians, the majority being women and children. With increasing geopolitical tensions and rivalries, war language has become normalized, and people are slowly becoming desensitized to the horrors of conflict. The peace and safety of the world has never been guaranteed by the size of states' weapon arsenal or their military spending. What could, however, bring more peace and safety to the world are peacemakers, humanity champions, and international humanitarian law advocates. State-to-state mediation is a crucial process that can bring about an end to armed conflicts and violence. Mediating peace agreements, ceasefire agreements, or agreements of prisoners' exchange have profound and immediate humanitarian impact on those living in conflict zones, but also an impact on global peace and stability. The peaceful settlement of disputes have the power not only to end armed conflict, but also to prevent future violence. States must find a path to dialogue again. The safety, health, and well-being of this planet rests on the shoulders of state leaders. I hope that today can mark the beginning of the end of disputes that escalates to violence. I want to thank the organizers once again for inviting the ICRC to be here today, and I wish the IOMED every success. Thank you very much.
Thank you, Mr. Kelasivig, reminding us of the very important role the mediator or the mediation can play in not just resolving the state-to-state disputes at a very high level, sovereign level, but actually affecting the livelihood of the people and, of course, the aspects of the international humanitarian law. Now, we have finished all the speakers on stage here, but we have one extra speaker who will be delivering a video speech online. His Excellency Gideon Hassabon, Minister of Foreign Affairs of Ethiopia. I believe somebody will be playing the video, and I'm sure it is on now. So thank you.
Good afternoon. Good afternoon. Your Excellency, Mr. Wang Yi, Minister of Foreign Affairs of the People's Republic of China, Your Excellency, Dr. Sun Jin, Director General of the IOMED Preparatory Office, distinguished ministers, excellencies, esteemed delegations, invited guests, ladies and gentlemen. All protocols observed. At the outset, allow me to express my heartfelt appreciation to the government of the People's Republic of China and the IOMED Preparatory Office for hosting this important signing ceremony and for their unwavering efforts in bringing the establishment of the International Organization for Mediation to fruition. Although I regret not being able to join you in person, it is an honor to share this message on behalf of the government of Ethiopia. My sincere appreciation also goes to all the participant states for the commitment and the role played in the process of the elaboration of the Convention for the establishment of IOMED. It is the conviction of Ethiopia that an international organization like IOMED plays an indispensable role in ensuring peace and the primacy of international law, as well as in strengthening cooperation between countries. Distinguished delegates, the government of Ethiopia believes that the establishment of the IOMED as the first intergovernmental organization committed to resolve international disputes through mediation will have a very significant contribution to global peace and security. At this critical point in time, when the world is witnessing conflicts of different nature among various actors, it is a timely action to institutionalize mediation. Ethiopia firmly supports the establishment and development of the IOMED as a strong international body capable of effectively addressing disputes and facilitating peaceful dialogue, to mediating conflicts and promoting cooperative solutions among nations. The establishment of IOMED signifies a commitment to peaceful conflict resolution and a belief in the power of diplomacy, dialogue, and mediation as essential tools for addressing disputes and preventing conflicts from escalating. Excellencies, distinguished delegates, today history is in the making with the birth of a new international institution dedicated to the peaceful resolution of disputes through mediation in line with the principles set out in the United Nations Charter. The establishment of IOMED highlights the value of resolving conflicts through peaceful mechanisms. Established in a spirit of multilateralism, it is our belief that IOMED will complement the existing international institutions and dispute resolution mechanisms in a constructive manner. Our common aspiration for a just and equitable international order has brought IOMED into realization. Ethiopia is pleased to be a founding member of this organization, which is created through our concerted effort and assure its readiness to sign the convention. Finally, I would like to reiterate Ethiopia's unwavering commitment for the establishment of IOMED. I thank you.
Thank you very much. Ladies and gentlemen, this concludes panel 1 on state-to-state disputes, and I would like to ask you all to join me in thanking the excellent panelists again.
Thank you. Thank you very much.